Something unusual happened at the Supreme Court, and most people didn't notice it at first. There was no dramatic announcement, no nationally televised hearing, and no weeks of public argument. Instead, a decision arrived quietly, almost clinically, through the court's emergency process. Yet, despite how quickly it came and how little attention it initially received, this ruling moved a line that had been stable for decades. And once that line moved, the entire structure around it began to shift. At its core, the decision was not about one policy or one political fight. It was about who has the authority to decide when laws take effect and how far courts can go when stepping in to stop enforcement. That may sound abstract, but enforcement is where law becomes reality. A law that exists only on paper does nothing. Enforcement is what turns words into consequences, protections, penalties, and power. For years, enforcement in the United States has often been shaped not just by Congress or the executive branch, but by individual judges. And when a law or policy was challenged, a single federal court could issue a nationwide order blocking enforcement everywhere. Even if only a few plaintiffs were involved, the result applied to the entire country. Over time, this practice became common, even expected. Supporters saw it as a necessary safeguard. If a law was likely unconstitutional, stopping it nationwide prevented harm while courts reviewed the issue. Critics saw something else entirely. They saw unelected judges effectively setting national policy by freezing enforcement before the democratic process could play out. That tension simmered for years without a clear resolution. The Supreme Court's recent move addressed that tension directly. The majority concluded that the line had drifted too far. Courts, they argued, are meant to resolve specific disputes between specific parties. When remedies extend far beyond those parties, courts begin to exercise a form of power the Constitution never granted them. In other words, the judiciary was no longer just interpreting law, it was shaping it. This ruling did not eliminate judicial review. It did not declare laws immune from challenge. What it did was redraw the boundary of judicial reach. Courts can still rule against unlawful actions, but the impact of those rulings must be more closely tied to the people actually before the court. That change sounds procedural, but its consequences are structural. The speed of the decision matters just as much as its substance. Emergency rulings are not routine. They are reserved for moments when the court believes waiting would cause significant harm. By acting quickly, the justices signaled that the existing enforcement framework itself had become a problem. This was not about correcting an isolated error. It was about preventing a pattern from becoming permanent. Almost immediately, the legal system began reacting. Federal agencies started reassessing programs that had been stalled for months or years due to nationwide blocks. Policies that were once frozen everywhere suddenly became active again in many places. State governments began reviewing where enforcement could resume and where legal barriers still existed. Lawyers scrambled to understand what strategies still worked and which ones no longer applied. For businesses, the implications are significant. Uniform enforcement once provided clarity. A rule was either on or off nationwide. Now, enforcement may depend on location. A regulation could be active in one state and paused in another. That creates compliance challenges, higher costs, and more uncertainty. Companies must now track not just federal rules, but how those rules are applied region by region. For individuals, the change is more subtle but equally real. Laws affecting immigration, healthcare, education, labor, or voting may now feel different depending on where a person lives. Two people subject to the same federal statute could face different realities simply because one lives inside a judicial district covered by a ruling and the other does not. To supporters, this reflects federalism in action. To critics, it raises concerns about equal treatment. The dissenting justices focused heavily on those concerns. They warned that limiting judicial remedies could allow unlawful government actions to persist while litigation slowly unfolds. In their view, nationwide orders were not power grabs, but practical tools. Without them, they argued, rights could become uneven and protection could depend on resources rather than principles. The majority acknowledged those risks, but made a different judgment. They emphasized that constitutional design matters more than convenience. If courts stretch their authority to achieve desirable outcomes, they undermine the very system meant to protect rights in the long run. From this perspective, restoring limits strengthens legitimacy, even if it creates short-term friction. This decision also changes incentives across the system. Agencies may feel more confident enforcing policies without fearing that one unfavorable ruling will shut everything down nationwide. States may be more willing to experiment, knowing enforcement battles will be localized. Advocacy groups may need to rethink litigation strategies that relied on sweeping relief. Perhaps the most important shift is political. When courts step back, responsibility moves forward. Legislators and executives can no longer rely on judges to resolve disputes quietly. Policy outcomes become more directly tied to elections and public accountability. That aligns with the majority's belief that democratic processes not judicial shortcuts, should shape national direction. None of this means conflict disappears. It means conflict changes form. Instead of being resolved primarily through emergency injunctions, disputes will increasingly play out through elections, legislation, and prolonged litigation across multiple courts. That process is slower and less predictable, but it is also more visible. The Supreme Court did not claim this approach would be painless. It claimed it was necessary. By moving the line back toward constitutional boundaries, the court accepted the risk of short-term disruption in exchange for what it sees as long-term stability. Whether that trade-off succeeds remains to be seen. What is certain is that the line has moved. The balance between courts, agencies, states, and elected officials has been recalibrated. And when foundational lines shift, nothing built on them stays exactly the same. This ruling did not change everything overnight, but it ensured that everything going forward will be different. Now the consequences of that shifted line are beginning to surface, and they extend far beyond the courtroom. When the Supreme Court redraws boundaries, it does not merely affect lawyers and judges, it reshapes how power is exercised on the ground, where real people feel its effects. One immediate result is fragmentation. Enforcement is no longer automatically uniform across the country. Instead of a single nationwide pause or green light, laws may operate differently depending on geography. A policy blocked in one region may proceed freely in another. Supporters argue this reflects constitutional design. Critics argue it introduces confusion and inequality. Federal agencies are adjusting quickly. In the past, a single unfavorable ruling could shut down an entire program nationwide, forcing agencies into long periods of inaction. Now, agencies may proceed in jurisdictions not directly constrained by court orders. This gives them more flexibility, but also more responsibility. Each enforcement decision carries greater political and legal weight. States are also recalculating their strategies. Some see opportunity, others see risk. Without broad judicial shields, states must decide whether to challenge federal actions more aggressively or focus on enforcing their own priorities within narrower legal boundaries. This deepens the role of state-level politics and reinforces the importance of local leadership. For advocacy groups, the landscape has changed dramatically. Litigation used to offer a fast track to nationwide impact. That path is narrowing. Instead of one decisive case, groups may need to file multiple lawsuits in multiple jurisdictions, often simultaneously. This favors organizations with resources and infrastructure, while smaller groups may struggle to be heard. Businesses face a different challenge. Compliance becomes more complex when rules are enforced unevenly. Companies operating across state lines must track not just federal law, but how that law is applied in each region. Legal uncertainty increases costs, slows decision-making, and complicates long-term planning. For ordinary Americans, the change may feel distant at first, but it is real. Workplace rules, healthcare access, immigration enforcement, environmental protections, and voting procedures may now vary more sharply based on location. Rights still exist, but their practical enforcement may depend on where someone lives and which courts have acted. The majority of the Supreme Court sees this as a feature, not a flaw. In their view, courts should not function as national policymakers. If a law is flawed or harmful, the solution lies in legislation, elections, or executive accountability. Judicial restraint, they argue, strengthens democracy by forcing political branches to own their decisions. The dissent fears the opposite outcome. They worry that without broad judicial intervention, unlawful policies may persist for years while challenges slowly move through the system. In that time, harm may occur that cannot be undone. From this perspective, limiting courts risks weakening protections when they are most needed. Both sides recognize the stakes. This is not a technical disagreement, it is a philosophical one. It asks whether stability comes from strong judicial oversight or from strict adherence to constitutional limits, even when outcomes are uncomfortable. Over time, the system will adapt. New legal strategies will emerge. Lower courts will refine how narrowly they issue remedies. Appellate courts will step in more frequently to resolve conflicts. The Supreme Court itself may revisit these boundaries as real-world consequences become clearer. Politically, the shift places more weight on elections. When courts step back, voters must look more directly to lawmakers and executives for results. That increases transparency, but also raises the temperature of political debate. Fewer disputes will be quietly resolved in courtrooms. More will play out in public view. This ruling does not end disagreement. It redistributes it. Power moves away from individual judges and back into a system that depends on legislation, enforcement, and accountability. That system is slower and messier, but closer to constitutional design. The Supreme Court did not claim this approach would solve every problem. It claimed that preserving structure matters more than managing outcomes. By moving the line, the court accepted uncertainty in exchange for what it sees as legitimacy. Whether history judges this moment as a correction or a mistake will depend on what comes next. What lawmakers do, how agencies act, how courts respond, and how citizens engage. One thing is already certain. The line has moved, and once it moves, the entire system must learn to live with where it now stands.